potential lawsuit. That's not as good a result, because if you have a pattern of dismissing complaints because the complaining employee wanted you to and you didn't follow up on an investigation, and then at some point down the road you do have an investigation that goes forward, you do have an instance of sexual harassment, the plaintiff's lawyer is going to argue that, look, you've had all sorts of red flags and you never followed up. There was pressure on these employees to drop their complaints from the company or from somebody within the company, and so the employer never followed through, and that's why you have a hostile work environment. If there is a pattern of not following through on these investigations, that can do you much more harm than good in the long run, even if you have written releases from the employees who initiated those complaints. Again, to avoid potential defamation claims, only interview the witnesses who have actual knowledge, and don't ask them about broad legal conclusions. Did you see anything that might constitute harassment? Ask them specific factual questions. Were you there on this day? Do you remember this conversation? Tell me what was said. Who said what to whom? Can you remember word for word what was said? Get the specific facts from them. Don't go beyond that. Remind them that the investigation is confidential, and of course, as with all things that we do, we want to make sure the investigation is carefully documented. We can go to the next slide. Once the investigation is complete, we need to take the appropriate action. Sometimes that's termination. Sometimes it can just be a formal warning. Might be charm school for the accused, maybe some one-on-one training. It might require demotion or transfer or suspension. You have to decide what's appropriate. I would suggest that you err on the side of too much discipline than too little. You certainly don't want it to come out in the courtroom one day that you have been lax in enforcing your harassment policy, or you've just slapped people on the wrist for what might be perceived as egregious conduct. So if you're having a hard time deciding, I would suggest that you err on the side of too much punishment. And of course, you don't want to penalize the complaining employee. That is the quickest way to get into trouble. Even, let's just say, by way of example, that the underlying complaint did not have merit, that it was frivolous, that maybe there was some ulterior motive that the employee had in lodging the complaint. And that happens a lot too. As soon as the employer takes some adverse action against the complaining employee, even though the underlying harassment claim was bogus, the now retaliation claim that that employee has is very legitimate. In other words, they can sue the employer for retaliation regardless of whether their underlying claim was good or bad. And so you don't want to set yourself up for a very real lawsuit on a very real claim of retaliation. And you've got to watch it, because a lot of times employees who know that maybe they're on the bubble, that they are not long for employment with this particular company, they're going to start looking for ways to protect themselves. This is one way they do it. They may go file a complaint with OSHA. They may go file a complaint with the EEOC. They may do all sorts of things that are considered protected activity, so that if it looks like the employer terminates them sometime shortly thereafter, what must have been retaliation, when in fact their head was already on the chopping block, so to speak. You want to be very conscious of that situation. It happens quite a bit, particularly in a tight job market like we have now. And again, document everything that we do. We talk about electronic communications. There are some challenges there, because there's sort of this, well, what did the employer know? What should the employer have known to have prevented this from happening, this entire work environment from being created and existing? And if we're talking about emails, well, you've got thousands of emails sent every day. So what is it that an employer is supposed to do to protect its employees from things that might be considered offensive or unwanted that are sexual in nature? Are they really supposed to read each and every email? Well, that's a challenge. There is software out there now that helps the employer monitor its email. We all know about firewalls. And again, this is going to depend in part on the type of operation you have, but there is software out there that will also monitor the internal communications and it will filter for things that are generally considered risky. It's going to look for certain language, certain types of images, and it will identify those. And you can use that software to identify those communications as best you can, and it's not going to be foolproof, but as best you can, and then you can have those communications sent to somebody responsible for reviewing them. Again, the employees know they don't have an expectation of privacy, and so they know the company can and will monitor their electronic communications. And that's what we, in fact, need to have happen. Because the software isn't available out there now, plaintiffs may make the argument that this is something that a reasonably diligent or prudent employer should have in place if they're actually going to take the necessary steps to protect their employees from a hostile work environment. It may become something that the courts look at and say, well, that's something that can be reasonably expected of you, the employer. And so you, the employer, want to take a look at this type of software and see if it's something that you can employ to monitor these communications and make sure that when something pops up that might be considered inappropriate, that you are in a position to address it. Another challenge is, how do you archive your information? Again, you've got thousands and thousands of emails going every day. How do you archive these electronic communications? And I'm getting ready to pass the ball here, but you know, there's been competing philosophies out there. Well, we'll archive you know, everything. Well, that can be a little unrealistic. You know, and for how long? Just years and years and years. And then others would say, well, we won't archive anything. We really don't want to leave a paper trail of any sort. If they can't find it, they can't hurt us with it. Well, you're going to have to keep track, obviously, of a number of your communications. And in reality, you know, we've talked about time and again here documenting these actions that we're taking. It is a CYA effort, but you're going to want to keep track of that, and you're going to want to save it, and you're going to be able to look back and say, here's what we've done time and again when this has come up. This is what we did to address it. Here's what we did over here. You want to be able to protect yourself by being able to go back and lay out we call it a paper trail. Obviously, in today's age, it's probably more electronic in nature, but you want to be able to demonstrate that you have a paper trail where you have done everything that you are supposed to do. And, of course, there's a whole host of reasons related to the operation of your business where you want to be able to save and protect information. So your challenge then is to figure out what you're going to save, what you aren't going to save. If you get into this e-discovery process and it looks like you haven't been saving what you should have been saving, you can get in trouble with the court, and they can sanction you. And there are instances where the court has told juries that, hey,